All right, today is September 28th. The panel this morning, as you can see, is Judge Callahan, Judge Sutton, and myself, Judge Teodosio. We are going to hear one oral argument today. That would be case number 21CA0005-M, State of Ohio versus Susan Luntz. Each party will have 15 minutes to present their arguments. Of course, the appellant may reserve up to 5 minutes for rebuttal. I'm going to ask Judge Callahan to keep track of the time, and she'll notify you as you get close to those time limits. Appellant, just let us know if you do want to reserve and how much time you would like to reserve, and Judge Callahan will keep track of the time for us. As you know, the oral arguments are recorded and are posted on the court's YouTube channel. So we ask that you keep your voice up so we have a good recording. And also, you're both probably aware that our Court of Appeals has a rule that because we record and post these arguments online, we ask that you refrain from using the names of children or victims during your presentation. I can assure you that all of the judges on this panel have read the briefs, and we're ready to proceed if you are. So if you're ready to go, let us know how much time you'd like to reserve, and we'll hear from you.
Thank you, Your Honor. On behalf of Ms. Luntz, I'd like to reserve 5 minutes if necessary. Again, Your Honor, Joseph Matthews on behalf of Susan Luntz. This case, I know we raised on paper 6 assignments of error, but I really believe that they should almost be set in groups. The first group is the group that relates to the filing of the leave to plead and the motion to suppress that occurred. This matter had been taken on with an attorney different than Attorney Caro. Attorney Caro appeared, and then approximately 36 days after his appearance, but more importantly, 12 days after receiving discovery, he filed, consistent with this district's ruling in other cases, he filed permission. He filed a leave to plead, and he attached to that what would be a very specific motion to suppress. The trial court initially granted the leave to plead, accepted the motion to suppress, and set it on the docket to be heard. The state of Ohio then filed a motion to reconsider, cited time, which I believe the trial court, and having the docket in front of it, would have known that this motion was effectively filed. I don't have the exact count, but I would agree that it was well outside of 35 days after the case was initially arraigned. But while I know the state of Ohio focuses in on the 35 days from arraignment, the other side of the rule says, or 7 days before trial, and in the interest of justice. And here, in the interest of justice, we do have legitimate issues that could only have been raised in a suppression hearing. The first issue would have been the horizontal gaze Nystagmus test. If we look at the trial testimony, which starts about on page 192, the officer concedes that there are 5 horizontal gaze Nystagmus instructions, and he only performed 2 of them. The second issue would be the walk and turn test, and that's on transcripts 193, 196, and 197. The Officer Ghetto, concedes and agrees that he failed first to give the instructions as it relates to staying in a position. But he also said, well, I told her not to stay in that position. I counted those points against her anyways. So on an 8-point test, 2 of the points that were counted against Ms. Luntz, she was never even given those instructions. Then as far as the method and manner in which she is to turn at the completion of the first 9 steps, those instructions were never given and never properly demonstrated. And he agreed to this. The officer agreed to this during his testimony. But these aren't trial issues per se. These are admissibility issues under 4511.19G1, which says standardized field sobriety tests and their results may be admissible if conducted in substantial compliance. This district, as well as every other district in the state, has said the substantial compliance issue is a threshold issue that must be raised prior to trial. I believe the state of Ohio would agree that the proposed motion to suppress and the leave to plead was filed 12 days after obtaining the video. That's not an unreasonably long period of time. That's not a period of delay. The state of Ohio was in no way prejudiced by that. And I believe the court did get it right when it initially granted the leave to plead. So when we look at the standard here,
Counsel, pardon me. I just wanted to get some clarification on a point. You mentioned that the trial court reconsidered the motion and ruled ultimately in denial. But when it did so, it didn't just do that on the basis of time, did it? It also ruled that there was no good cause shown. Is that correct?
I don't have the order in front of me, Your Honor, but I do believe that is correct. And I do disagree with that conclusion that there was no good cause, because in this matter, this wasn't a boilerplate motion to suppress. It wasn't a motion to suppress that says there was no reason to stop and tests were done improperly. This gave specific examples of what the officer did incorrectly and what we believed should be suppressed. So I believe that was good cause. And there was a switch in counsel too.
So just to be clear, the court did rule though on the merits, didn't it?
Of the motion to suppress?
Mm-hmm.
Your Honor, no, I do not believe. I believe the motion to reconsider.
Oh no, I mean I'm sorry, on the leave to plead. I'm sorry. On the merits of the leave to plead.
It initially granted on the merits of the leave to plead and then reversed saying, so I mean, you have two inconsistent decisions. So when we're talking about a Rule 12 motion, I think our case law across the state is consistent on this. That leave to plead should have been granted the first time, and it was. I do disagree with the court's decision, the trial court's decision on why it granted the motion to reconsider. I'm sorry, looks like you're going to say something.
Yeah, I was. As I understand it, there were a couple of things, right? And tell me if I'm wrong. The state was never served with the motion, so that was part of what the court looked at. But the court also reviewed the motion on the merits and ultimately denied it because they didn't. It found that there was nothing, no good cause from the criminal Rule 12H waiver. Is that correct?
That's what the trial court found. Yes, I would agree with that. I would agree with that, and I would say that the trial court respectfully got it wrong on the Rule 12H section, because 12H should not be, especially when we look at the federal cases on this issue. Federal cases make it clear that local state rules should not be a bar to somebody being able to challenge evidence, whether that's the Carr case out of California, 9th District, excuse me. Or our local cases here. This isn't a wall that should be a barrier to switching from an attorney who had filed essentially no motions to, within 12 days of getting discovery, having a complete motion to suppress filed. Just fundamental fairness. And that's what I think 12H does say, is 35 days after arraignment, 7 days before trial, or in the interest of justice. And I think we need to read that rule as a whole. And this wasn't a leave to plead that was filed at the end of the 35-day period saying, hey, we haven't received discovery yet. This was at the end saying we've now finally received the discovery from the state. Because if we, and that's, there's many reasons to do that. In this case, I believe that the trial court got it wrong. We should have had the hearing on the suppression, and we can see from the record there were viable issues present. The next issue was the motion in limine striking the doctor. I believe that the trial court had two findings. It had a Rule 403 finding. The 403 finding was, while there is some probative value here, I find it to be minimal, and the risk of confusion outweighs. It did make that finding, but that finding is confusing when we look at the other comments made by the trial court, which did indicate that there was value to this testimony, but the trial court mistakenly concluded it had to be through an expert. And doctors, treating physicians all across the state testify in trials all the time without being qualified as an expert, whether it's a sane nurse testifying in a rape case or a doctor testifying as to seeing a broken arm as a result of a felonious assault. This is the same thing here. This doctor would have testified that Ms. Luntz, and I believe the state agrees with this, that Ms. Luntz did in fact have a form of nystagmus, and that form of nystagmus would have eliminated 1/3 of the horizontal gaze nystagmus test. And I don't believe there's any contradiction or any disagreement on that. The trial court, though, erred when it said the only way this testimony could come in was if that was through an expert. I think the trial court was mistaken in the sense that it focused in on, would this doctor be testifying that alcohol wouldn't have caused this, or there was no testimony going to be offered other than she was previously diagnosed with this, she had the condition, this demonstrates nystagmus. And I think to a jury, when there is no breath test, and I know I have that in my brief as well here to talk about, that is probative. That's highly probative, especially when you get into the NHTSA manual, which describes how, when you go from 6 out of 6 clues to 4 out of 6 clues, and how that lowers the certainty that the person is impaired. It's a declining scale. That's why they set the threshold where they set the threshold. And that probative value is important. So I do believe the trial court erred there. As it relates to the Doyle and the Mommy versus Astanek issues regarding the right to remain silent, the prosecution is correct in the sense that the prosecutor is permitted in certain circumstances to comment on a refusal. The case law on that goes back to the 1930s and 1940s with blood testing. There's no doubt that the current state of law is that the prosecutor can comment. However, the prosecution went too far in this case. And I hesitate to raise that the implication of prosecutorial misconduct, but it's not the culpability of the prosecution. It's merely whether or not the prosecution's comments were violated the defendant's rights and whether or not prejudice flowed from that. Here we have, first, as it relates to Doyle.
Excuse me, were there objections made during the trial?
Your Honor, there were objections made all over the place on this.
And I didn't want to interrupt you, but go ahead. I just want to make sure that it was objected to.
There were both objections and there were sidebar conversations regarding this, Your Honor.
Excuse me a minute. I was engrossed in your argument and wasn't watching the time. I apologize. You are into your rebuttal time. So you're welcome to keep going. I just wanted to let you know.
Very, very briefly, and I will come back to this in rebuttal. There are 3 comments that stand out to me that I'll address right now. The first is the prosecution made the comment of right versus wrong on transcript 283 to 284. He made a misleading statement that we all know a single glass of wine can put you at a 0.04. He directly called Ms. Luntz a liar at page 285. He commented directly on her right to remain silent by saying she had to explain why she had an odor of alcohol on her. And those are all Doyle violations, Doyle versus Ohio. These are pre-arrest, right to remain silent, has absolutely nothing to do with whether or not she took a breath test or was going to refuse a breath test. I would now reserve the remaining balance of my time, whatever it is that I have left. Thank you.
Okay, you still have close to 4 minutes, almost.
Thank you.
Sure.
All right, Attorney Campbell.
Thank you, Your Honors. May it please the court. I'm Robert Campbell, Assistant Medina City Prosecutor on behalf of the state of Ohio. Your Honor, on the late filing of the motion to suppress, the entire timeline is important. The defendant was arraigned, and I don't have the date in front of me, but the 74 days, I believe, the motion to suppress, leave to plead that was ultimately filed was 109 days after her arraignment and 74 days after the expiration of the 35-day limit for filing of a motion to suppress. The Judge Werner of the Medina Municipal Court has a right to control his own docket and has a right to apply Criminal Rule 12 as it's written. What defendant is asking the court to do is completely ignore the existence of Criminal Rule 12. And it's important to note that even if the trial court would have given the defendant an entirely new 35 days to file a motion to suppress from the date that new counsel entered its appearance, they were still late in filing their motion to suppress or their leave to plead. So counsel enters its appearance, new counsel enters his appearance. 36 days later, they file a motion for a leave to file a motion to suppress. So in this situation, this defendant did not miss this timeline or time deadline once. She missed it twice.
What's the timeline from the point where second counsel received discovery?
Second counsel received discovery, I believe, and I would assume that the dates cited by counsel are correct. Counsel got paper discovery, which would be the entire narrative of the arresting officer, which outlines the infractions that he saw, to know that the stop was made because she was leaving a bar at 2:34 in the morning and driving without her headlights. They would have known that on December 4th, would have known that she presented with watery, bloodshot eyes and an strong odor of an alcoholic beverage. They knew that on December 4th. They knew that a description of her performance on the 3 standardized field sobriety tests, and knew that she denied consuming any alcohol, whatever, and refused the breath test. All of that on December 4th. 8 days later, on December 12th, defendant received the video in this case, which would be a dash cam, at the minimum, a dash cam camera video of the stop and the encounter between the defendant and the police officer. And I also believe Brunswick Hills Township has body cam as well. So that was on December 12th of 2019. 15 days later, on December 27th, is when the leave to plead the motion and file the motion to suppress was filed. I'd also like to note, Your Honor, that Judge Werner did not initially grant that motion. What happened was there was an acting judge on the day that the motion hit the desk, and the judge just signed his name to it. There was no analysis. There was no reasoning behind it stated in the order. It was just a signature from the acting judge. Based upon the state's request for Judge Werner to review the motion, Judge Werner then reviewed the motion and filed a rather extensive, or a journal entry with a rather extensive analysis as to why he felt that this 109-day late motion, or excuse me, after arraignment, 74-day late motion was not reasonable, and was not that there was not good cause for it being so late. I know that counsel has referred to his belief that the judge got it wrong. That's not the standard. The standard is whether the judge abused his discretion. And I believe that it's very difficult in this situation, based on Judge Werner's extensive explanation of why he was doing what he did, that an argument could be made that that was an abuse of discretion in this situation. Regarding this medical doctor that they wanted to call, this medical doctor indicated that she believed that there were potentially 2 eye-related conditions that this defendant had, one of which, and this is important, she said could affect the lack of smooth pursuit portion of the horizontal gaze nystagmus test, that it might, but there was no statement proffered of any certainty of probability that the lack of smooth pursuit that Officer Ghetto observed at the scene was caused by this condition, as opposed to being caused by the defendant's consumption of alcohol. Importantly, the doctor examined the defendant in this situation and found that that condition did not present any lack of smooth pursuit. So the decision or the testimony that defendant was offering was speculation upon speculation. She has this, it might cause it. It didn't cause it when I examined her. I can't say whether it would have caused it or not on the night in question. Importantly on that as well, Judge Werner granted a motion to in limine. At trial, there was no, that evidence was not offered at trial.
Counsel,
Yes, ma'am.
I'm sorry. Maybe I was going to ask you a question, but maybe you're not going to say what I thought you were going to say. Were you going to say that he didn't preserve the motion in limine
Yes.
by objecting?
Yes, or calling the witness at trial.
So he didn't proffer.
Correct.
That's different than preserving it by objecting, though, isn't it?
Well, it was his, yes, it was his or her, the defendant's evidence. So I believe that when there was a ruling on a motion in limine that says we're not going to allow that evidence, still at trial, the proponent of that evidence has the obligation to attempt to present that again, to have preserved their right to appeal the trial court's decision. I'm still a bit befuddled. I'm moving on to the closing argument objections. I'm still a bit befuddled by what the defendant is complaining of. In this case, the defendant insisted from the moment she had contact with the arresting officer on the road to the moment that she finally said, I am not going to take a breath test, that she had consumed 0 alcohol that night. None. That, if it was true, would give the defendant no concern of jeopardy in taking that breath test. The point that I tried the case, the point I was making to the jury was a person who might have consumed a glass of wine at dinner may have a reasonable fear of taking a breath test. They're a lay person. They don't know what 1 glass of wine might do in relation to a breath test. That fear did not exist here for this defendant, because this defendant insisted that she had consumed no alcohol. That goes right to the consciousness of guilt. It goes right to the directly to the credibility of her statements that she made to the police officer when she chose to speak. She never, when the officer asked, have you had anything to drink tonight? She did not exercise her right to remain silent. She made an affirmative statement. I did not. I have consumed no alcohol. That is a fair statement for comment regarding the believability of the defendant's assertion that she was, 1, had consumed no alcohol, and 2, was not guilty of this offense. So that was the focus of the closing argument. There was no effort made to suggest that she had any specific breath alcohol content. I don't know how they've come up with that because it wasn't said. It was simply an argument that a person who insists that there was 0 consumption of alcohol has even presents even a greater consciousness of guilt when they refuse to take a breath test. Your Honor, I know that counsel did not get to the point of arguing his manifest weight position. This also goes to the motion to suppress question as far as what the facts at trial show. And I think they're important as I wrap up. The facts at trial showed that the defendant was leaving a bar at 2:34 in the morning, that she drove out of that bar parking lot without using her headlights and drove for a significant period of time without having her car properly illuminated. She admitted that when she was pulled over by the police officer. The police officer was confronted then with watery eyes and mumbled speech and a strong odor of an alcoholic beverage emanating from the vehicle. The officer asked the defendant to exit the vehicle, which she did, but she didn't close her car door and left her car door open in traffic. The officer had to go back and close the door. He then began to perform the standardized field sobriety tests. And Your Honor, I believe the trial record shows that those were done within substantial compliance with the NHTSA rules. She had a very difficult time getting the defendant to concentrate on following the instructions for all of the tests. He had to repeatedly tell her to stop moving her head during the horizontal gaze nystagmus test. She argued with him about how to perform that test, and he saw 6 out of 6 clues. Her performance on the walk and turn test showed basically 8 out of 8 clues. She did practically nothing correctly on the walk and turn test. She did not touch heel to toe. She did not take
What's your comment as to opposing counsel's argument that she was not instructed thoroughly or properly on how to take the test?
Yeah, I believe the trial transcript shows that she was instructed properly. I believe what the officers, I mean, look, the operative instruction for the horizontal gaze nystagmus test: stand with your feet together, hold your head still, and follow the stimulus with your eyes. That is the instruction for the horizontal gaze nystagmus test that has any effect on the performance of that test. Now, he had to tell her that several times because she continuously moved her head, looked away, refused to follow the stimulus.
Were the instructions deficient on any of the tests?
No, Your Honor. No, Your Honor. And she was completely incapable of performing any of them. The walk and turn test, or the one leg stand, she started counting and performing the test without ever even lifting her foot off the ground. So not only was she physically impaired, but she was mentally impaired in that she was completely incapable of following the instructions that were given at the most basic level. So, Your Honor, Your Honors, the state of Ohio would submit that, and again, on all of the judicial issues for review are abuse of discretion tests. I believe it's an abuse of discretion test on the witness. It's an abuse of discretion test on the motion. There's just been beyond disagreeing with him, the defendant has not shown anything that shows that they were arbitrary, capricious, or unreasonable. And we would ask the court to deny the appeal and affirm the conviction below.
Perfect timing.
All right, thank you, counsel. And we'll move on to the reply then.
You have 3 minutes and 52 seconds.
All right, can you just make sure, can you hear me? I'm on a new device today.
We can hear you.
All right. It's important to, and I always say this to a jury, not to rely upon what we're saying, but as attorneys, but to actually look at the transcript and the record. The prosecution, all throughout its brief and in an argument here, makes a big deal about she quote, left the door open. But when we look at transcript page 186, the officer agrees, I had my hand on the door when she got out of the vehicle. Question, would it be reasonable for her to conclude that you were going to close the door? Answer, yes, that's reasonable. The officer had his hand on the door that he just opened after Ms. Luntz got out. So Ms. Luntz did not leave her car door open in traffic. That's entirely misleading and not supported by the transcript. At page 192, as it relates to the horizontal gaze nystagmus test, again, going to what's in the record, the officer never instructed Ms. Luntz to keep her head still. So this entire narrative that he had to keep telling her to keep her head still is not supported by the record. For instance, question, you're supposed to tell her not to move her head. Answer, yes, but you didn't do that. Correct. So he didn't tell her that initially. And then it goes on to, he explains, yeah, I didn't tell her to do that right away. So these facts that the state of Ohio is asking the court to rely on here aren't supported by what's in the record. When we come back to the comments that the prosecution is befuddled by, the comments were directly in the record. He directly says a glass of wine would have put her at a 0.04. She could have been at a 0.08. Heck, she could have been at a 0.1. That's at page 284 to 285 in the transcript. He says at page 283 to 284, this is about determining right versus wrong, that she didn't explain why she had an odor of alcohol on her. That has absolutely nothing to do with refusing to take a breath test. That is a comment on her refusing to give an explanation, which is precisely what Doyle versus Ohio protects. Doyle versus Ohio, the officer testified, or detective in Doyle testified that the defendant did not give an explanation as to the crime. That was reversed in federal court. And that has been the law of the land here for several years. There is only one comment in the record that I can find, and I'm willing to be wrong, but there's only one comment that I can find. It's at page 185 in the transcript, where, I'm sorry, 158 in the transcript. Question, did the defendant take the test? No, she refused. Which gets us back to Maumee versus Astanek, which is where the limited right to comment on a refusal comes into play. It's not a carte blanche. Just because somebody refuses doesn't mean that the Fifth Amendment goes away entirely. It has to be tied to the refusal, and here there is no tying to the refusal because, for instance, in Maumee, that defendant was worried that her blood pressure medication would impact a blood test. So the Supreme Court of Ohio found that that was an issue, that was a fact at issue, was her concern about her blood pressure medication impacting her blood test. Would that be sufficient for commenting on her right to remain silent? And as of note, the Supreme Court reversed her conviction in that case, and that was because the prosecution went too far. So there is this mistaken belief, I think, out there amongst some quarters that says if you refuse, you get to say whatever you want to say as a prosecutor. That's not accurate. And finally, as it relates to the motion to suppress issues, I believe we have, when I say the court got it wrong, I'm relying on our briefing and what we filed. Of course, it's an abuse of discretion standard. I apologize if I was not more clear on that. The trial court was arbitrary. It was capricious when it reversed the prior granting of it.
Counsel, with that, your time's up.
Okay, well, then I will rest on what I have already said and what I've already argued. I appreciate everyone's time.
Well, thank you both for excellent presentations today. Thank you, Judge Callahan, for keeping time for the court. The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will mail the decision to each of you on the day it's released, and the opinions, as you know, are also posted on the Supreme Court of Ohio's website. We're going to adjourn today, and the next oral argument is Thursday, September 30th. That will be via Zoom as well. Thanks again, counsel, for your good arguments, and you enjoy the day.
Thank you, Your Honor.